Hello, my name is David Archuleta, and I'm a county court judge in the 20th Judicial District. I'd like to discuss small claims cases in county court. Small claims cases can be some of the most challenging and rewarding of all types of cases we're involved with as judicial officers. Although attorneys are sometimes involved in these cases, they predominantly involve pro se parties. As such, the judicial officer needs to be mindful of the challenges and opportunities this provides us. Small claims cases are authorized by statute 136402 of the Colorado Revised Statutes and governed by the Colorado Rules of Procedure for Small Claims, Rules 501 through 521. There are several good ways to conduct a small claims trial, but each method begins with a general introduction to the process. Many jurisdictions actually have written small claims description forms or videos that they show the interested parties to prepare them for the trial day. Some jurisdictions also have case management orders that explain the process. Here is a copy of ours. A very basic orientation begins by describing who goes first to the parties, who has the burden of proof for both the claim and the counterclaim, and a discussion of the relaxed but not absent rules of evidence. As a bit of a digression, the rules concerning small claims cases indicate that, quote, "The hearing of all cases shall be informal, the object being to dispense justice promptly and economically between the parties. Rules of evidence shall not be strictly applied. However, all constitutional and statutory privileges shall be recognized. The parties may testify and offer evidence and testimony of witnesses at the hearing," end quote. There has also been discussion of whether cross-examination of witnesses may be allowed or not in a small claims case. My personal practice has been to allow it at times and not at others, depending on the nature of the case at trial and the ability of the parties to ask questions rather than to make statements. Another critical point that should be made is that Rule 512B authorizes the court to require settlement discussions between the parties so long as the court does not participate in the discussions themselves. In many jurisdictions within the state, the courts also have the help of mediators who are often volunteers and sit down with the parties to help them attempt to reach a resolution of their case. It is important to remember that whether or not you have mediators available to help you, that you should encourage the parties to sit down and discuss the case if they will. Often in small claims cases, the day of trial is the first opportunity the parties have had to see each other in person since the dispute started. The judicial officer should not assume that the parties have exhausted all opportunities for settlement. At a minimum, encourage the parties to have a discussion and to do so if they can in good faith. In our jurisdiction, we use an agreement to mediate, which is a form which usually reduces any fears the parties may have about the process. Some other basic suggestions for the judicial officer as you begin the case is to require that each party exchange all exhibits and list each witness for the other party. You should, in your written materials or self-help video, mention to the parties that they will be required to follow this procedure. It will make the trial more efficient and manageable for all of those involved. Before the trial starts, assure each party that they will have the opportunity to be heard, but remind them that you may or may not dispense with the formalities of a regular trial to ask questions or seek clarification. This gives you maximum leeway to tailor the proceedings to the circumstances of each case and avoid surprise if you take a more active role in the presentation of materials. Once the trial has begun, you should help the parties focus the issues if they aren't sufficiently clear. Often a case is very straightforward and the issues are clear to all. However, sometimes the issues have not been clearly defined. This is where you can do a great deal to help the parties by defining what needs to be decided and what is superfluous. Again, the important thing is to tailor your approach to the contours of this case. Some cases take a lot of management and some not so much. As the subject matter of the small claims case can be varied, it is hard to be a master of all subjects. One very useful practice is to review the pattern civil jury instructions if you're not familiar with the elements of a particular type of claim. By doing this on a regular basis, you become familiar with the most common types of cases and improve your knowledge on more unusual types. You may also want to create a cheat sheet or some other type of form that would help you in small claims cases. This is useful as many times you want to be able to cite the appropriate elements of a statute and rule from the bench in an efficient manner. Because small claims cases involve many varieties of dispute, now is a good time to discuss what cannot be tried in small claims. Currently, small claims cases involve damages not to exceed $7,500 for the claim or the counterclaim. The parties may not be represented by a lawyer typically, unless the defendant chooses to have one, and then the plaintiff may as well. Attorneys must file a notice of representation by an attorney no later than 7 days prior to trial. Here is a copy of this form. Small claims also have procedural rules that are different from the county and district court. A small claim case may be removed to the county or district court if the amount claimed by the defendant exceeds the $7,500 jurisdictional limit of the small claims court. Notably, if a case is transferred to the county or district court, the small claims rules still apply pursuant to Rule 520E. Any natural person may commence or defend an action in small claims. Also, corporations, associations, or other organizations may be a party in a small claims case. For partnerships, an active general partner or an authorized full-time employee may represent the partnership. A union may be represented by an active union member or full-time employee. An association or other kind of organization may be represented by one of its active members or employees. Notably, property managers can also represent landlords in landlord-tenant disputes. This is different than county and district court rules of civil procedure. As for actual trial procedure, no discovery or motions are allowed. There is no right to a jury trial, and magistrates may hear small claims cases unless a party objects in a timely fashion pursuant to Rule 511. When a case is set for trial and the defendant has been properly served or given notice by certified mail, and then the defendant fails to appear in court, the court may enter a default judgment against the plaintiff pursuant to Rule 515. If a case proceeds to trial and a judgment is entered in favor of a party, the losing party must either pay the amount of the judgment immediately, or, if unable or unwilling to pay, must fill out small claims interrogatories in court before they leave the courtroom. The court may allow the losing party to pay the prevailing party or complete the interrogatories at a later date if there's an agreement on that. If a defendant fails to answer the interrogatories or pay the judgment, the prevailing party can compel enforcement of these orders by the use of show cause orders or contempt proceedings under Rule 518. As a last matter, small claims cases can be used to enforce restrictive covenants on residential property pursuant to Rule 521. I have rarely been asked to hear these types of matters myself, but that just could be a matter of local practice in each jurisdiction. Concerning how you make your findings, I find the following ideas useful. Try, of course, to make thorough findings. Recite at least a line from each witness testimony to show the parties you really did hear their case. Do not be afraid to say someone's testimony is not compelling or make some other credibility findings. Then review the elements that have been proven, what items of evidence either support the elements or have been left out. And you may also take a short recess even when you're pretty sure what your ruling is going to be, just to underscore that you have given the case careful consideration. Lastly, when advising parties about the right to appeal, I usually stress to them that there will be no additional evidence offered to the reviewing court, so that all the evidence that the judge, you, just reviewed is the basis for any appeal. I tell them that they have 14 days to file the appeal, and that you may or may not stay the judgment pending the outcome of the appeal. The role of the judge in small claims cases is to dispense justice. Even if the defendant defaults, the plaintiff may not have a cause of action that can be supported or may not have calculated damages correctly. The court has a responsibility to sort this out. Some courts even put the plaintiff under oath for information about damages in a default situation. In conclusion, small claims cases test the imagination and energy of judicial officers as they require substantial interaction with the pro se parties, the evidence, and the rules of the case. As such, they can be challenging but also rewarding, as the judicial officer is authorized to be more than simply a neutral magistrate. Neutrality is still of paramount importance, but reaching a prompt, fair, and justified judgment is the goal of the small claims case. I wish you all good luck in your small claims cases.